probable cause found. Yes, Judge.
Jordan Caldwell. Ms. Caldwell, you were charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. The officer is dispatched to a residence in Harris County, Texas, in response to a family disturbance. The complainant stated that she got into a verbal argument with the defendant, her daughter, because the complainant believed the defendant was not taking care of her children. At that point, the defendant picked up a baby bottle and threw it at the complainant, hitting her in the cheek, causing pain. The defendant admitted to having thrown the baby bottle.
And I'm going to find that there's probable cause to go forward with your case. I don't show a protective order as an issue. Do you show one? No? Okay. Ms. Caldwell, I'm entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Candy Lachey as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand? It's not an answer, ma'am.
Yes.
How old are you, ma'am? Are you here with anyone today? Who are you here with today?
My boyfriend.
I'm sending you now for a drug test. I want to know what, if anything, is in your system, ma'am. You're to come right back. If you fail to take the test, if you fail to come back, I will issue a warrant for your arrest. You will not get any more PR bonds. Do you understand? Okay, can you have her sign the note before she leaves, and then we'll send her for a test, please?
You're done with it, Your Honor?
For now. So just normal reset. Everything is normal.
Okay.
Nothing special. Just stay out of trouble.
I believe her bond conditions require her to not go to the residence at issue. Her two children, right, are still there, and I'm not clear who
is the complaining witness again?
her mother.
Do we know if mom wants her back?
Let me see if it's been. It has. Let me read this.
The only time I say no is when the complaining witness says no, because I want to honor their wishes. If the complaining witness is okay with it, then I am too.
Your Honor, the complainant is fine with contact. She just wants no threatening, harassing contact.
Okay, that's it. We'll let you go back to the home, but you have to understand what is threatening or harassing. Doesn't matter what you think. I'm trying to.
Understand?
Okay, I'm listening.
It's how she perceives. So when you start going like this, is that threatening or harassing? It is. So be careful how you act, because if we find that you're threatening or harassing the complaining witness, I will revoke the bond and put you in custody. All I'm asking you to do is be nice. That's it. If you constantly bang heads with your mom, be careful, you know?
Not only that, you could also get charged with violating bond conditions, all right?
Protective order. And
Protective order.
yeah.
Can we make sure the protective order mirrors the bond conditions?
Sure.
Okay.
Caldwell, do you mind printing out? Okay, ma'am. We've given you a lawyer. It's your responsibility to stay in touch with Corey. He'll tell you when you have to come back to court. I'm going to waive your appearance so you don't have to waste your time coming here, but just stay in contact with him and he'll tell you when you have to come back, and just be nice. If mom kicks you out, where are you going to go? You got two kids too, right? That's what you got to think about when you're out there. You just get in a fight with mom, they kick you out, where are you going to go? And you got two kids. You can stay here with us. I don't think you're going to like that though. It's not, it's not fun. Okay, so I'm going to amend the conditions and then you guys are good to go.
Okay, thank you, Judge.
For sure. Thanks, Corey. Come on.
So go to the middle.
I have a Norma Solano on today's docket. It looks like she had missed a drug test for bond. We're here for
Is she
bond
here
violation.
now?
Oh, yes, Judge, she's here.
Okay.
And she said she was not aware that she had the drug test. I don't know if the manner in which they contact them, I thought they'd maybe call them for that. But she was originally going to do DWI PTI. She now says she would like to take a time served offer. Would you allow her to do that today?
Why? Why she doesn't want to do the,
Judge, she just said she
you know
doesn't.
what's he going to test positive for? Is that what it is?
No, Judge, but she just said that the expenses of the program, and she's working right now and she doesn't have time for the program.
Come up, Miss Solano.
But we had already gotten her approved and we're kind of on our way to, I think we might even have the contract already even for DWI PTI.
How old are you, ma'am?
25.
Okay. You know, being in court, it's not like being in Target, Costco, HEB, where if you don't like something, you can return it or you get buyer's remorse. When you make decisions in here, they're lifetime decisions that you have to live with forever. And, you know, there are collateral consequences that may arise, meaning consequences that you may never see pop up as a result of decisions that you make in here. When you plead guilty to an offense, that offense goes on your record and it's there for the rest of your life. And when you plead guilty, you can't take it off. You cannot say, you know what, I have a change of heart. I can't get an apartment. You know what, let me go and try to do something else. Once you plead, you're stuck like Chuck for the rest of your life. I tell you now, I have, you know, every month, people that call me, they go, you know, this lawyer pled me to this case and I can't get an apartment. Can you take it off? I have, like, they pled 10 plus years ago. You know, truck drivers that want to better their life, but they pled guilty to a, you know, a less than a gram case and can never take it off. When you plead to a DWI, not only is it very possible that you lose jobs with regard to, you know, making a living with a car, your insurance is going to go up. Your insurance is going to skyrocket. Insurance is expensive as it is now. You pick up a DWI, it's to be about 4 times what it is now. Not to mention any other consequence that can arise from a DWI conviction. You have the opportunity now where if you are granted entry into this program, if you complete it successfully, they dismiss the case. It looks like you've already have been granted entry into it. The only problem I see now is that you were called upon to take a drug test and you failed to go. I'm going to go send you for a drug test regardless, right?
Yes, sir, that's fine.
Right? But when you take a half-ass approach to something, you get a half-ass result. And it's usually not a good idea to do that with a criminal case.
Now,
You know?
listen closely here. This
When
is
you
one of
try
those
hard,
moments where Judge
get a good
Fleischer
result.
switches from
You know,
judge to
James
life coach.
worked hard to
The
try to get you
defendant
into
is
this
considering
program.
taking a
Has she
time-served
been
plea,
already
which
admitted
means
into
she
it,
would plead
you know?
guilty and finish the case today.
She's not in PTI,
But the
Judge. She's
judge
in
is
Right,
warning
right,
her
right. But
about
right,
the
I mean-
long-term
Yes, Your Honor,
consequences.
the last
A
update was
criminal
that the
conviction,
contract was signed, the
especially a
NDA was
All
in
you
DWI,
literally need to do
doesn't
are
just
2
mean
things. You pay
fines
the
or
DA
classes.
fee
It can
and you get
follow
an
someone
NOR.
for
The
decades,
DA fee, if
affecting
you fill out a
jobs,
waiver,
housing,
they
and
may
even
be able to
insurance
waive that
rates.
$300 fee. As far as the interlock, I can't pay for that. I can only pay for it while you're on bond. That's something that you'll be required to pay for. But I tell you now, the $50 to $75 cost you per month now is nothing compared to what you will end up paying with the DPI conviction. So you make the decision on what you want to do. I am going to send you for a drug test right now, regardless,
That's fine.
and alcohol test.
Yes,
But think long and hard before you make this decision because there's no turning back from it. Okay? Okay, man. Just hang tight for me.
You want to approach?
Sure.
Judge, we got Norma Solano's test results and she came back negative. What I was gonna,
Oh, hold on.
Oh,
hold on.
sure, Judge.
Who is it?
Miss Solano, you sent her to go get tested?
Is that Miss Solano?
Yes, Judge. She's right over there.
Come up, Miss Solano.
That's kind of a alternative as opposed to having her plead today. Maybe we can get.
No, I don't want her to.
No, I know you
She
don't.
doesn't want to.
She wanted to do time served today, but I was thinking just instead of that, because she's already has the contract, maybe we can give her a couple weeks to talk to some friends and family and see if she would rather
What
go.
do you want to do?
You said you want to do the time served, or you think you want to do the 1-year program?
Well, I was iffy in the beginning. I just wanted to do the time served, and then I talked to my friends and my family, and they suggested to do the program. But since I got
Anytime you can get something dismissed, no matter how, that's always the best result, really, because like I told you, the consequences of a DWI conviction, they're staggering. You never know how it's going to affect you. It will. It's going to affect you. It's just, you never know how and by how much. And with the DWI is big business. You plead guilty, from now on, you're looking at a minimum of 30 days in jail. You're also looking at a mandatory about $6,000 to $7,000 in fines and fees just here from court, not to mention insurance going up, not to mention all the other stuff in your life, how it's going to affect you. Whereas if you do this program, you do well, maybe they'll even boot you out early. If you do everything speedy, you do it quick, maybe they'll take you out early too. Just depends on how well you do. But you have to put effort into it.
yes,
All you do is, there's 2 classes, right?
There's a couple classes and then it's the alcohol monitoring device.
And there's 2 classes, a little community service, and just stay clean. That's all you have to do.
I have clients regularly do everything in 6 months.
Take your time. I don't want you to rush into something now. So we'll set you off a couple weeks. In the interim, do we have the financial affidavit so we can have her doing that as well?
I can send you a copy of the financial affidavit to waive the $300 fee if you qualify, but you'd need bills and pay stubs and all that to be attached. I can send that to her, Judge.
Please. And I think we may even have a copy here actually for you. So, try to get that $300 fee waived, and then all you have to do is pay for the interlock and just stay clean. What do you think? We'll give you time. I'll give you a couple weeks. If you still want to do the time serve, that's on you. If you want to do the program, great. It's up to you. Take your time.
I think
Yeah, just
Rush.
talk about it.
Take
yes,
your
sir.
time.
Thank you, Judge.
I'm glad that you're clean and don't miss again. Okay? All right. Good luck, Ms. Solano.
Thank you, Judge.
For sure.
Hey, quick question.
Ricardo?
Thank you. Ricardo.
Antonio. What's his name?
His name is Cesar Alvaro.
Good morning.
Yes.
Your lawyer has tried to work out an agreement with you. The problem is that it's going to take a while. And sometimes for a good result, it may take a while for that to happen. Here, his advice was for you to set it for trial. But unfortunately, because of the holidays coming up, normally we do a 30-day trial setting. But 30 days from today runs into the Christmas time, and we don't have any juries here. So the first jury trial setting that we have is for January 7th, and he wanted to set your case for jury trial on that day to see whether they can make the case or not. I know that you're itching to get out, but you got to understand that if you plead today, there are very serious consequences. You're charged with assault of a family member. This carries an affirmative finding of family violence. What that means is that if you ever pick up another one of these cases again, you will be charged with a 3rd-degree felony, and you will be looking at a minimum of 2 years in prison, a maximum of 10 years in prison. And when I mean an assault, it doesn't have to be a beat down with blood everywhere. Simple fact is you grab someone's arm and squeeze it to where it hurts. That's enough for them to charge you with a serious felony where you're looking at 10 years in prison. If you do this, you can never own a gun or ammunition as well. So the advice by your lawyer is for you to wait a bit and set up a trial January 7th. What would you like to do?
¿Qué quisiera hacer usted?
Mejor si lo espero el 7 de enero.
I'd rather wait for the January 7th.
Okay. Antonio?
Yes, sir.
There you go.
Yes, sir.
Yeah, and we'll set up a trial for January 7th and we'll see what happens. You know, that's the advice of your lawyer. I would, you know.
Okay.
Yeah. Okay. Here you go.
Yes, sir. Okay. All right. Thank you, Your Honor.
All right. Absolutely.
Okay. Okay. Yeah, this was the last one.
Okay.
Good morning. So, Mr. Hercules, you were charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. You guys have worked out an agreement where they're offering you 3 days in jail, credit for the 18 days that you've done. You sure?
Yeah.
3 days in jail, credit for the 18. You know, the way that you were driving in that parking lot, God forbid that you hit someone, kill them, run someone else over, driving out like that and then bolting out at 90 miles an hour in a parking lot. You're begging for trouble, man. Can you imagine if you hit and kill someone? Who gets charged with murder? Mr. Hercules.
You're right.
So, you know, in a parking lot, that's not the right place to do it. If you want to do it, there are places in Houston, but not in a parking lot, man. How many racing facilities are there in this town? I mean, a lot. Don't do it again. I'm going to tell you one more thing, that the legislature has made it really easy for DAs across Texas to seize and take cars away from individuals who do this. You are now going to end up with a conviction for this on your record. You pick up another one of these cases, it's very possible that they seize and take that car forever and you don't get it back. Do you understand?
Yes, sir.
The right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never change this. Is this what you want to do? How do you plead to the offense? Guilty or not guilty?
They give me the time served.
Yes, you get the time
Yes.
served.
Are
Guilty.
you guilty of this offense?
Yes, sir.
Okay, all right. I'll find you guilty. I'll send you the agreement. Now, we're not going to release you today because Louisiana wants you. So you'll probably Monday or Tuesday be out of here and then on your way to Louisiana. Okay? Good luck over there.
Thank you, sir.
All right. Take care.
Yeah, I like
Mr.
your sports jacket. It looks nice.
Thank you, sir. Take care.
All right, Mr. Rickus, have a good one. Your Honor, may I be excused? Thank you, sir.
And with that, that's it. You done?
Well, you're good. Failure to post.
Oh, okay.
In your honor, briefly on Williams, were those state's conditions or pretrial for the marijuana? Is that a state's condition for bond or pretrial?
Good job.
Okay.
Did you want random testing or just?
Do you know why you're here?
Yes, sir.
Why are you here?
Because I didn't finish my community service, and my clerkship I did finish, Your Honor, but I got into a tight budget, very, very bad.
One of the only other things we asked you to do, don't use drugs or alcohol.
Yes, sir.
And now you're testing positive for cocaine. You tested positive for cocaine in February, and you've just now tested positive for cocaine again. Take a seat for me in the jury box, sir.
Good morning, Your Honor. Good afternoon, Your Honor.
Yeah.
Judge, I am here on Mr. Alejandro Guardado. Looks like it's an MRP judge. I've been informed that
Come up, Mr. Guardado.
my client had tested positive for cocaine, I believe. I think this is his second or third time testing positive. We want to know what direction you.
Hey, this isn't the club, man. You. So you trying to talk to her. This isn't the club, man.
Yes, sir. No, sir.
Yes, yes, sir. Yes, sir.
Hit you, brother. Mr. Guardado, you were placed on probation for a very serious case, and you've had issue after issue. The reason I brought you here was try to ensure that we could get you on the right path, but you're continuing to use, and you just today tested positive for cocaine again. And I'm at a remiss that they didn't even inform us in February when the first time you tested positive for cocaine. So now I'm issuing a motion to revoke your probation, and I'm issuing a warrant for your arrest. I've appointed you a lawyer so we can figure something out, but you can't continue to use cocaine while you're on probation and expect good things. Do you understand?
Yes, sir.
Okay. So what I would suggest at this time is we probably get a TRAS to see how we go forward, because I just don't know.
Yes,
You're
sir.
using, and that's not something you're supposed to be using, you know? It goes with you.
Yes, thank you.
All right.
How much you said in the bond, Judge?
What's it at now? 5,001.
Judge, I have Evan Nelson, and we're approaching because of the age of the case. Wanted to also just update you as to what's going on with it.
Okay.
We have talked, my client and I, and we have asked the state to evaluate this one for trial. They did make a 3-day time served offer, which I presented to my client, and he is not amenable to accepting that, just based on the elements of the offense, and we talked through those.
You know, Mr. Nelson, the only problem I have is that you don't show up. We've already had, you've been given one GOB, you've been given one PR bond, and now you've made a surety bond. You miss again, I'm gonna make your bond so high, your hair's gonna look like mine. You know what I mean? You're gonna be losing it because you're gonna be so upset. So don't miss again, really. Giving you a great lawyer, all you got to do is stay in contact. What offer have you made on Mr. Nelson's case?
It looks like Pavel had put in a time served offer when he was still on.
Is that it?
I'm welcome. I mean, I'm happy to talk to counsel, about another
Okay.
offer. This is just an old offer put in by Pavel.
Okay. Oh, yeah, it's a prior assault dismissed. Okay. We'll give you guys some time. It's not going to be too much time because your case is already 190 days old. So it's time to figure out what we're going to do. We'll give you, 3 weeks, but at that time you got to come back and we got to figure out what we're going to do. At that time in 3 weeks, if you don't accept anything, I'm going to set your case for trial. Okay. All right, guys.
Thank you, Judge.
Good luck. See you in 3 weeks.
Have a good weekend.
Sure. Is there gonna be any bond conditions? Because we just put them in the box straight away.
Just no weapons, I guess. That's it. He's a prior AFM, so yeah.
All right,
Okay.
let's take
So
one.
Morgan, do you mind following? Just no weapons.
Yes, Judge.
If it's not already there, I don't know. So no PTI?
No PTI,
She knows about it, right?
yes. Oh, I'm sorry.
Morning, Ms. Hutcherson. It's Hutcherson. So you no interest in doing the PTI program?
She's currently in the
You're
PTI
wrong. She was
program.
just
She's
removed
terminated.
from
Oh, she was removed? Oh,
I didn't have a.
got it. No, yeah, too late. Okay, so Ms. Hutcherson, you've worked out an agreement where they're offering you 3 days in jail, credit for the 1 day that you've done. You need to understand, ma'am, yeah, I just see that removed. You need to understand that this DWI will go on your record. It's going to be there for the rest of your life. You need to understand that if you ever get pulled over, an officer is going to look at your history. They're going to see this DWI. If you smell like alcohol or dope, it's not going to go well. The other thing, what we're doing today, it's not going to, you're looking at a minimum of 30 days in jail from now on for whatever you pick up. So no more proverbial slaps on the wrist. You understand? You're giving up the right to a trial, right to compel witnesses, testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will stay on your record. You can never take it off. This is what you want to do. How do you plead to the offense, ma'am? Guilty or not guilty? I will find you guilty. I will send you to the agreement. What do you do for a living, ma'am?
I work as a receptionist.
And how much money do you make?
I bring home
I want you to understand something, ma'am, that, you know, DWI is big business. There's a $3,000 surcharge that usually is tacked on when you pick up a DWI. And when you get a second DWI, it's a $6,000 surcharge. And if you don't pay it, you go to jail for every $100 that you owe. You understand? I will waive your fees now. I'm not, it's next time, it's around $7,000 you're going to be walking out. So if you want to get lit, just don't get into a car. $20 a button will take you anywhere you want to go. All right. Good luck.
Thank you, Judge.
You run it. Oh, I have to suspend your license. I'm suspending it for 180 days. You are Aziel Gracia.
Sir.
Mr. Gracia, so
He's charged with, I've never seen this before, Judge, but he's charged with violating a bond condition.
yeah, I mean, I've certainly seen it.
And,
It's either
It's not a protective order, it's a bond condition.
right because they can't make the protective order case because it's been more than 61 days,
It had
right?
nothing to do with the protective order, Judge.
So yeah, right. I get it.
It was a different situation completely. Had nothing to do with family violence.
Get there. So you're charged in violation of a bond condition / protective order. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. If you cannot afford a lawyer will be appointed to represent you. So before we start, was he in a PTI? Is that why this case is 1,000 days old?
Yes, sir. He just has a few BIP classes left to finish the PTI.
Okay. Okay, go for it.
Judge. The officer was dispatched to a business in Harris County, Texas, in response to a disturbance. Upon arrival, the officer observed the defendant grab another male aggressively, and the officer conducted a search on the defendant's person and found a loaded gun in the front pocket. The defendant is currently on bond for an assault family violence and has bond conditions in place prohibiting from possessing a firearm.
Yeah, all right. Mr. Gracia, I'm going to find that there's probable cause to go forward on the bond conditions. State, what's your position as far as he's in a PTI? He's now picked up a new case. Mr. Gracia, I want you to know that we take these bond conditions extremely serious.
Sir.
You don't, though. This is not your first VPO. This is not your first violation of bond condition. You don't get it. No means no. Doesn't mean maybe. Doesn't mean I'm going to a high crime area. No means no. And now there are consequences. Stephen.
Judge, can I tell you a little bit about the case?
Sure.
You know, like, just to explain to you what happened. He was at his business. He owns a trucking company. He hired somebody who he said he took a chance on him because has a sketchy record, convicted felon. It didn't work out within a couple of days. So he ended up firing the individual. The individual refused to leave the premises or refused to accept it. So he started threatening him. He went inside. The individual started trying to damage the trucks. So at that point, he was fearful. He went and retrieved a firearm that he knew was hidden in the vehicle. I'm sorry, in there. I understand, Judge. And
it's about the worst thing that you can do. Imagine if you use the firearm. Who gets charged with murder, Mr. Gracia? Who has now dug themselves into a potential 50-year hole? We have a case like that today where a meager argument, someone who's charged with assault is now charged with murder because of a silly ass, stupid ass argument. Now dude is sitting in custody with a $250,000.
And he's been punished at this point, Judge. He's been punished for violating the bond by getting an entire new case on that. So as far as him going into custody for violating the bond condition, I would hope that you would take that into consideration, the fact that he has gotten punished on the bond violation already, and the fact that he's already had to hire a new attorney for two cases at this point, and it's probably going to affect the other case. So I would hope that you would continue supervision on that, just taking that into consideration.
I truly appreciate your position, but you have an assault from 2019 of a family member. The following year, you pick up a violation of a protective order or bond condition. Now you have another assault that they were even, what the hell you're looking over there? Was it Jesus over there? You already have an assault of a family member that was dismissed as it is. You were lucky enough to even have this kind of an agreement where they're willing to dismiss a second assault of a family member. And now you pick up another violation of a bond condition. Eric, he doesn't get it.
I understand.
You don't get it. And now I have to show you, we mean business. I think that you are utter and complete danger to public safety. And I will do everything in my power to protect my public in every single way. Because the last thing I want is you to pick up a murder case like we have here this morning. Someone else goes with you.
Judge, one more thing. There's a bond condition on there that he's not allowed to return to that address. That address is his business. It's his place of business. The other person has no right to that address. So he hasn't worked for the last week and a half because there's a bond condition, I'm assuming from the magistrate, that doesn't allow him to go back to that business.
Show me proof.
I'd like to be
Show
able
me
to take
proof. And, you know, the proper, you know, and you need to advise, the proper way to do things is you call the cops. Really. I mean, that's, if you own the business, you show it. I mean, how easy would it have been to just call police?
I mean, he has a right to defend his property and
not while the case is open. He does, but not in that manner.
It's one of those things where things happen quick and you have to make a decision. And when we're talking about trucks that are worth hundreds of thousands of dollars and things like that.
911, man. Really?
How long do they take to get there, Judge? So
okay. They will still take his ass to jail and then, you know, you try to get restitution or whatnot. But
so as far as the bond goes, can you set him a bond today?
Of course.
And Judge, we've contacted Conrad because it's his case.
This might be the most serious moment in the entire hearing. The defendant was already on bond for an assault case, and one of the conditions of that bond was no firearms. But police say he was found with a loaded gun in his pocket during another disturbance. In the eyes of the court, that's a massive red flag. When someone violates bond conditions, especially involving weapons, judges often see it as proof the person cannot follow court orders. And that's why Judge Fleischer is getting visibly frustrated
trying to get
here.
back on his feet. He did everything properly. He didn't go back to the location because of the bond condition.
I'm not doing $500. I mean, I was thinking that was going to mirror the same one. I was put it at 20,000.
And that would be his state's position to mirror.
So he understands that we mean business. You know, if he's unable to bond out, I'm always willing to talk after a couple days, you know, but I want him to understand that we take it absolutely serious. And when you go over there with a gun with the intent to do some serious damage, hell no. No way. No. And I think that making it 20,000, what the other one is, hopefully it'll get his attention.
Okay,
but like I said, look,
10,000?
Like I'm not out for blood, Eric, you know, so if he's unable to, after some time, come back, and I'm not talking weeks, but you know, a couple days, so he realizes that we mean business.
So we're talking about 2 weeks minimum. So would you consider getting 10,000?
Well, remember, I Zoom, so you can be in Abu Dhabi. I'm still here.
His mom's present. So let me talk to her.
Yeah, for sure. Okay. You were Samuel Torres. Mr. Torres, you're charged with driving while intoxicated It's elevated to a Class A misdemeanor because of the high blow, so you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. Okay. On November 14th, 2024, the officers observed the defendant's motor vehicle make a wide right turn at an intersection with a dividing concrete median, accelerate at a high rate of speed from the intersection, failed to maintain a single lane, moving halfway into the center lane before returning to the outside lane, cross over a solid white line into a bike lane before returning to the lane, and the officer observed other cars in the area at the time, rendering the failure to maintain a single lane dangerous to the other motor vehicles. The defendant's motor vehicle stopped at a red light and remained stopped after the light turned green, obstructing traffic, and the officer then initiated a traffic stop once the defendant's motor vehicle finally proceeded through the intersection. The officers had to travel approximately 0.5 miles from the original location as the defendant continued to drive. The officer made contact with the defendant, the driver, and the officer observed bloodshot eyes, an odor of an alcoholic beverage, and the defendant stated he did not immediately pull over because he lives at the apartment complex where the traffic stop was eventually performed and did not want his vehicle towed. The defendant stated he was coming from his sister's house, and the officer observed the defendant using the motor vehicle to regain balance. The defendant stated he had one Long Island liquor drink that he was currently consuming inside the motor vehicle, and the officer found a frozen daiquiri still frozen and half consumed on the passenger side of the floorboard.
So he's drinking while driving?
Yes, Judge. And the officers performed standard field sobriety test, HGN 6 out of 6, walk and turn 7 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and consented to breath. The results were 0.151 and 0.160.
Mr. Torres, do you have a Texas driver license?
Yes, sir, I do.
I'm now taking away your privilege to drive. You are not allowed to drive at all for any reason. And I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing. You can be facing up to 6 months in jail and a $500 fine every time you get into a car and drive. Do you understand?
Yes,
From now on, you'll be taking the Dodge Patas. This is an affidavit that you're going to be signing with me today, promising me. And I don't care what your excuse is. If there's a burning building with 50 kittens you have to save, you get into a car and drive, we will have issues. I'm also ordering you not to consume alcohol or illegal drugs. I will randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail. You will not get any more PR bonds, sir. Any priority to be eyes, Alex? How old are you, sir?
Mid-30.
What do you do for a living?
I'm a mechanic.
How much money do you make a month?
About 24 right now.
Who do you live with?
My wife, my sister, my daughter.
Who else in the house works?
Just me.
Apply for an appointed lawyer, sir. So help me. Any issue, Mr. Torres, if I set your bond $5,000 to $10,000 and you ain't got anyone to pony up that kind of money, you will be stuck like Chuck until this case is over with. Make wise decisions while you're out there, because if you don't, I'm going to keep you. Do you understand?
Yes, sir.
Okay. Do you mind giving me an application, please? Have you application for an appointed lawyer? I need you to fill out everything. Don't just put zeros, because I'm going to send it right back to you. I'll have you sign a reset with Victoria. You're going to have to meet with Felicia for your bond conditions. And then we'll have you take a seat in the jury box.
Vasquez, Guillermo.
Jaquan Peterson.
Yes, sir.
Mr. Peterson, you're charged with reckless driving. You're facing up to 30 days and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On November 14th, 2024, the officer was part of a task force with the main focus being hostile street takeovers of and racers. A large group of motor vehicles were meeting at the 11700 East Freeway in a parking lot in Harris County, Texas, when the officer observed the defendant's motor vehicle enter an area of the parking lot and begin to spin his...
Si tú hablas, te pongo en la cárcel. Okay, sorry, please.
Would you like me to start from the beginning, Judge?
Please.
Yes, Judge. On November 14, 2024, the officer was part of a task force with the main focus being hostile street takeovers and racers. A large group of motor vehicles were meeting at the 11700 East Freeway in a parking lot when the officer observed the defendant's motor vehicle enter an area of the parking lot and begin to spin his rear tires with a loud screeching noise. The defendant's motor vehicle did several donuts, losing control of the rear end within 10 to 15 feet of other motor vehicles making up the pit. The officer observed the defendant's motor vehicle complete approximately 2 to 3 donuts, and a traffic stop was initiated. The officer made contact with the defendant, the driver and sole occupant, and the defendant admitting to doing donuts.
Run his NCIC. Does he have any other cases like this by chance?
I'll run his NCIC, Your Honor.
Please. Mr. Pearson, I'm going to find that there's probable cause to go forward with your case. Can you imagine if you start doing these donuts, you hit and kill someone? Who gets charged with murder? These are things you must consider when you're out there in the free world. You think before you act, think before you speak, because actions may be your last.
And Your Honor, he has no other open cases or criminal history.
Do you have a Texas driver license?
Yes, sir.
Do you have liability insurance in your name?
Yes, sir.
Can you run this license,
It's
please?
eligible, Your Honor.
I'm ordering you as a condition of your bond not to participate in activities like this again. No reckless driving, donuts, street takeovers, racing. If I find that you do, the first thing I'm going to do is take your privilege to drive away from you. And the next thing I will do is I will put you in jail. Do you understand?
Yes, sir.
610. The freeways, toll roads, parking lots. This isn't the right way to put. You don't do this over there. And I'm going to tell you now, the Texas legislature has made it extremely easy for DAs across Texas to seize and take cars for individuals who participate in these types of actions. And I've had defendants come here with their cars seized, $50,000 trucks taken because of these types of actions. So be careful out there, because not only can you next time go to jail, but you may lose that very car that you had. Can you file those conditions, please? No donuts, reckless driving, etc. We are going to reset your case to give you time to hire a lawyer. So I'm going to have you sign a reset with Victoria. After that, we will have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. When you come back, please have a lawyer, sir.
Judge Potter, page 16.
Hey. Robert Potter. Mr. Potter, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On November 17th, 2024, at 1:10 a.m. in the morning, officers conducted a traffic stop on the defendant's motor vehicle after observing it traveling at a high rate of speed, 67 miles per hour in a 45 mile per hour zone. Upon contact, the officer observed the defendant to be the driver and sole occupant and observed him with slurred speech, strong odor of an alcoholic beverage, and bloodshot, glassy eyes. The defendant admitted to drinking and scored himself as a 5 on a 1 to 10 intoxication scale. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 7 out of 8, one leg stand 2 out of 4. The officer observed the defendant to be disoriented, drowsy, had slow and sluggish reactions, was uncoordinated, unsteady, as well as disoriented during the tests. An inventory search of the defendant's vehicle revealed a 12-pack of 12-ounce Modelo's in the back seat, as well as a 6-pack of 14-ounce Michelob Ultra with 1 container left. The DICs were read and the defendant consented to breath, the results being .097 and .099.
Is there any evidence that he's consuming while he's driving?
No, Your Honor.
Mr. Potter, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license? Do you have valid liability insurance?
Yes, sir.
In your name?
Yes, sir.
Are you sure? Can you run his license, please? Any prior DWIs?
No, Your Honor.
I'm ordering you as a condition of your bond, Mr. Potter, not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any illegal drugs, unprescribed controlled medication, I will put you in jail. No more PR bonds. Do you understand?
Yes, sir.
How old are you, sir?
19.
What do you do for a living?
Gold maker. Work. Never find.
How much money do you make a month? We're going to reset your case to give you time to hire a lawyer. So I will have you go to Victoria, sign a reset. I'll get you with Felicia for your bond conditions, and after that, you'll be free to go. Be careful. Don't use. I don't care what your excuse is. If I find that you're using, there's a one-way trip. You understand?
Yes, sir.
Okay, man. Come on.
All right, Judge, next is
You said paid 8?
page 8.
Okay. Tatiana Green. Good morning. Ms. Green, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Okay. The complainant and the defendant have been married for 3 years. On November 17, 2024, officers were dispatched to a welfare check at a residence in Harris County, Texas, where the officers met with the complainant, who stated that the defendant and the complainant were having marriage issues due to the defendant cheating. The complainant stated that on November 17th, he observed the complainant laying on the couch, he observed the defendant laying on the couch talking to another man on the phone. An argument then ensued. The complainant stated the defendant grabbed a curtain rod and hit him twice on the leg while he was laying in bed. The complainant stated he called 911 because he was worried about safety and needed help. Just before the officers arrived, the defendant bit the complainant's left arm, causing pain. The officer observed the injury on the complainant's arm.
Do we know if he wants to have contact with her?
I'll read the RIF, but RIF was performed, so.
Okay. Ms. Green, it looks like a protective order has been issued in this case. Get to know it. If you violate it, the state will file additional charges against you. A violation of protective order, it's one of the worst cases you can pick up. Until I know that he wants to have contact with you, I'm barring you from having any contact with this person. Do you understand?
Yes, sir. So it appears that the complainant does not want contact and the complainant is moving out in order to make sure no contact.
Okay, do you have a child with this person?
No, sir.
Great. I don't want to talk about the case.
It's not about the case. The apartment that we have together is my apartment, but right now, since I got out, I've been at my grandma's.
So for now, right, this bars you from going to
Right away, this case takes a serious turn. What started as a
West
family
Mead
argument
place,
between
right.
a
So,
mother and daughter has now become a
you need a
criminal
lawyer to
assault
represent
case
you in
in
this
Harris
case.
County Court.
You need a
In
lawyer
Texas,
to represent
even
you in
something
this case,
that might
ma'am.
seem small,
Do you work?
like throwing an object during
I
an
do work. I
argument,
just started
can
working.
legally count as assault causing
Whenever I was
bodily
in
injury
court
if it causes
for,
pain.
like,
And
You get
now, Judge Fleischer is
a
about
lawyer
to
for the
issue something
magistration.
important,
I didn't talk to
an
anyone.
emergency
Okay.
protective
So
order.
what
That
kind of money
means
do you
the
make a
court
month?
is stepping in immediately
right
to
now.
prevent any
do you
further
support
conflict
yourself?
between the two.
Okay. Did you want to apply for a court-appointed lawyer, ma'am?
Yes.
The other option is you can go hire one. What would you like? Okay. Actually, I have one. So I have an affidavit already filled out. So what we'll do is I'll have you just sign a reset with Victoria. I'll have you sign here the order for protection, and then we'll have you take a seat. Don't leave until you sign our additional bond conditions, and then we'll have you talk to a lawyer here momentarily.
Okay.
Okay? Please.
It was already signed, Judge.
Oh, that's right. Okay. Yeah, we just need to sign the reset, and then we'll have you take a seat. No, come up. Well, no, the deal is that He's moving out, she's moving out?
He is moving out, and he previously told the prosecutor on the case that he has a new place, but I see on the MOAB that it does list the apartment that belongs to the
Got it.
defendant. Yes.
Okay, I want you to go back, but I want to make sure that the person is out first. Because I don't want you to go back, he's there and boom, just.
And don't talk about the facts of the case, just talk
No,
about
no,
this
no, no.
situation. Yeah.
My lease is up on the 7th of December, so I'm okay. I just need to get my personal belongings.
But if he's not living there, Your Honor, I mean.
I just don't know if he's still there.
I can reach out to him.
Do you mind real quick?
Yes, Judge.
Okay, they're gonna try to reach
Sure.
out to him real quick to see if he's still there. If he's not, and he's gone,
He's still there,
Until what day?
until December 2nd.
Oh, okay.
is he on the lease too?
No, I mean, he doesn't have to leave. I'm with my grandma. I'm okay. I'm okay.
Sure?
Yes. Yes,
Well, is there also,
I don't want to exclude you from your own home.
is there a no contact too?
it's okay because
Yes, Judge. Yes.
Did a no contact because he
Wants a
doesn't,
no contact?
yeah,
Yeah.
it's over. Allegedly.
Till next month?
I don't know. You never know. Time heals, right?
Okay, so you're for sure not going back there. He's
I can
gonna,
get back.
but what about December 2nd when he leaves? Do you need to go back? You said December 2nd he's getting out of there?
Well, he gonna communicate with my mom and my sister. That's how we've been conversing.
So let's do this. I'm gonna have Alex reach out to him. At a minimum, let's see when he's gonna go out. That way you have an idea. He's gone and you can go back because
Can your family go get your stuff if need be?
Yeah, I mean,
probably a lot of
And,
stuff.
and the reason we're bringing this up is because if you go to that address
I know,
and he calls the cops,
I know.
even if he tells you, invites you,
Mhm.
even if he's gone,
Mhm.
you will get charged
I know.
with a new charge, and I don't want that happening. So if he's out December 2nd, his last day, do you want to come back to court December 3rd? And we can,
I have to remove that residence restriction off. So if you go back, you don't get in trouble.
You don't have to do because I'm about to move. My lease is over.
right, but who's gonna get your stuff out of there?
But it's because it's only right that he lives the rest there because he paid the rent for this month.
Okay, well, I'm just trying to
I
get
understand.
her to get her stuff out without getting in trouble.
I'm gonna get it. My sister will get it for me. They don't-
Okay,
Ms. Green, you've got a great lawyer. If you ever need anything, reach out to Greg.
Yes, sir.
Greg knows how to get a hold of me and we can always work something out.
Yes, sir.
Just the worst possible thing you can do is take matters into your own hands, go over there, or because you'll end up picking up a new charge and then things will really go sideways quick. So just please don't. If you ever have any questions, reach out to Greg, he'll always talk to you and yeah, I mean, we're always here as well.
Okay.
We live here. So
okay, so then just I'll do a regular reset, and if you need something moved up, let me know and I'll get you here early.
Okay.
Okay?
okay, all right, man.
All right,
Am I able to leave?
not yet, I'm gonna give you a reset.
Let's get you the reset, all the paperwork.
All right, thank you, Judge.
Okay, thanks, Greg. Hannah, do you speak English, sir?
Flores José Antonio.
Acérquese aquí al centro. Solamente mire el juez y le contesta con respeto en español.
Claro que sí. Florencio Martínez Vázquez Guillermo.
Guillermo, yes, solo mire.
Charged with driving while intoxicated.
Solo mire el juez, por favor.
You are facing up to 6 months in jail and or $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one, sir.
Para usted, si usted no puede pagar por su propio. Solo quédese mirando el juez, por favor.
On November 17th, 2024, the officer conducted a traffic stop after observing the defendant's motor vehicle run a red light. Upon contact with the defendant, who was the driver and sole occupant of the vehicle, the officer observed the defendant with bloodshot eyes and a moderate odor of an alcoholic beverage. The defendant admitted to drinking and advised that he was coming from a party. Standard field sobriety tests were performed. HGN, 6 out of 6. Walk and turn, 5 out of 8. One leg stand, 2 out of 4. Inventory search of the vehicle reveals one open 12-ounce bottle of Modelo.
Drinking while driving.
DICs were read, and the defendant consented to correct. The results being .122 and .126.
Mr. Vasquez Guillermo, I'm gonna find that there's
Vamos a
probable
hallar que hay causa
cause.
razonable para
Case.
continuar adelante.
Tell me, are you a United States citizen?
Solo mira el juez, por favor.
Are you in this country with or without permission?
Permiso o sin permiso.
No, sin permiso.
No, without permission.
What happens if you go to jail?
¿Qué pasa si usted va a una cárcel? Acérquese, señor, y no me mire, por favor, solo al juez. ¿Qué pasa si usted va a una cárcel?
No, pues, no sé.
Well, I don't know.
Are you in this country with or without permission?
O sin permiso.
O sea, entré con permiso, me quedé.
I entered with permission, but I stayed, I remained.
If you go to jail
Usted va a una cárcel.
and immigration finds you, Mr. Vasquez, they will put a detainer on you and you will be stuck in custody until this case is over with. And then you will be shipped off to immigration where you will sit for another 6 to 9 months waiting for immigration to do whatever they're going to do. I would hope that you recognize it's elementary that you're not to have alcohol in the car while you're driving. And it is a minimum of 5 days in jail to any sentence you get if they allege the open container. I will tell you now that immigration sweeps it every single day. So if you spend more than 6 hours in custody, you'll be stuck like Chuck with an immigration detainer. I am now putting conditions on your bond, and if I find that you violate these conditions, you will go to jail in a moment's notice. And I don't care if you're kicking and screaming. Do you understand?
Señor? Sí, señor o no, señor?
Sí, entiendo.
You are not allowed to drive. And you will be signing with me today a promise that you're not going to drive. I don't care what your excuse is. If I find that you drive, to jail you will go. Likewise, I'm ordering you not to consume alcohol or illegal drugs. You will be randomly tested. If you test positive for alcohol or drugs, likewise, you will go into jail.
De igual manera la va a ir a una cárcel. That's fine, that's fine.
Any prior DWIs?
No, Your Honor.
Ninguno, señor. Solo mire el juez, por favor. Entienda eso.
Sí.
We are going to reset your case to give you time to hire a lawyer. So I will have you come up here, swear to us that you're not going to drive. This is an affidavit. I'm going to tell you now, Mr. Vasquez, look at me.
Míreme.
This is the only warning you will get from me. One violation whatsoever. I'm going to keep you with me. Do you understand?
¿Entendió eso, señor?
Sí, señor.
Yes, sir.
Okay, coming up here, swear to us that you're not to drive. We'll get you to Victoria, and then we'll get you with Fleischer for your bond condition.
All right, Judge, next is page 22, White.
Good morning, Ms. White. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. The complainant and the defendant are married. On November 16th, the officer was dispatched to a residence in Harris County, Texas, in reference to an assault. The officer met with the complainant, who stated the defendant and him had a verbal altercation that began the night prior, due to the defendant thinking the complainant was talking to another woman on the phone. The complainant stated he tried to sleep, but the defendant wouldn't stop arguing. The complainant stated that he slept in a separate bedroom, but the defendant came into the bedroom at 5 a.m. and started yelling at him, accusing him of cheating. The complainant stated he tried to walk out when the defendant struck him with a closed fist right between his eyes, causing him to feel pain and discomfort. The complainant stated he feared for his life and had no other choice but to call 911.
Okay, Ms. White, I'm going to find that there's probable cause to go forward with the case. Do we know if he wants to have contact with her?
Let me see if a RIF has been done, Your Honor.
Please.
No RIF has been done, Your Honor.
Okay. I don't know if he wants to have contact with you, so until I know, I'm ordering you not to have contact with this person. A protective order has been issued in this case. I would suggest you get to know it, because if you violate the protective order, the state can and will file additional charges against you, a violation of a protective order, and it's one of the worst cases that you can pick up. Do you understand, man? So you're not to have contact with this person and not to be in possession of any weapons. Do you work, ma'am?
I do.
What do you do for a living?
I'm school bus driver.
What kind of money do you make a month?
$1,000 a month.
Okay, we're gonna reset your case to give you time to hire a lawyer. I'll have you go to Victoria, sign a reset. After that, we'll just have you take a seat in the jury box, so we'll get your bond finished, you'll have you sign it, and then you'll be free to go, ma'am. Okay? Please. So no contact, no weapons, please. You were Aaron Durden?
Yes, sir.
Mr. Durden, you're charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, yes. Okay. On November 14th, 2024, the officer was on a traffic stop in Harris County, Texas with emergency lights activated when he heard an engine roaring of a performance motor vehicle and observed the defendant's Lamborghini on the feeder road traveling at least double the speed of moving traffic with a posted speed limit of 45 miles per hour. The officer observed the defendant's motor vehicle swerve in the feeder lanes and enter South Highway at a very high rate of speed without signaling a lane change. The officer terminated the traffic stop and attempted to catch the defendant. The officer observed the defendant's motor vehicle turning into a bar and initiated a traffic stop. The officer approached the motor vehicle and observed the odor of brakes and engine burning from aggressive driving. The officer observed the defendant to be the operator of the motor vehicle sitting behind the wheel and observed a strong odor of an alcoholic beverage and watery eyes. The defendant stated he was coming from Captain Tom's and standard field sobriety tests were started. The defendant then complained he had poor balance, and the defendant fumbled through his wallet trying to find his Texas driver's license and stalled when answering where he was coming from. The defendant was searched, and the officer found a receipt from a bar in the defendant's short pocket, and HEN eventually was conducted, finding 6 out of 6 clues. Walk and turn and one leg stand were refused. The D was read the DIC, but refused blood. A search warrant was obtained and executed.
Right, Mr. Durden, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to drive any vehicle that doesn't have an ignition interlock on it. That is a blow and go that you put on your car to make sure that you don't have alcohol when you get into a car. If I find that you drive a car that doesn't have one, I will put you in jail. You will not get any more PR bonds. Do you understand?
Yes, Judge.
I'm also ordering you not to consume alcohol or illegal drugs, and I will randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, you will go to jail. No more PR bonds for you, sir.
Yes, Judge.
Understand that we send notice to DPS in Austin so that any and all officers know if you get pulled over, you're to be driving a vehicle that has an interlock. And if you drive one that doesn't, they will immediately take you to jail. So beware that the all-seeing eye knows. You understand?
Yes, Judge.
We're going to give you time to hire lawyers. So I'm going to have you go to Victoria, sign a reset. You will then get with Felicia for your bond conditions, and after that, you'll be free to go. All right?
Judge.
Okay. Please. Hi, Billy.
What is that?
Jose Antonio Guzman Flores. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
The complainant and the defendant are in a dating relationship. On November 16th, 2024, the officer was dispatched to a residence in reference to a disturbance. The officer made contact with the complainant, who stated she and the defendant began to argue when she discovered the defendant gave her an STD. The argument began as verbal. The complainant wanted to leave, and the defendant grabbed the complainant's wrist and began to pull her. The defendant then grabbed the complainant's purse, which was wrapped around her waist, and then began to pull her hair. The complainant and the defendant separated when officers arrived. The defendant stated he did not put his hand on the complainant by grabbing her wrist, and pulling her because he wanted her to calm down. The officer observed an injury to the complainant matching her statement.
So you said pull the hair? Is that what you said?
He pulled her hair, yes, Your Honor.
And did you say that it hurt?
The complainant did state that she felt pain.
All right. Okay, Mr. Flores, I'm going to find that there's probable cause to go forward with the case. Do we know if she wants to have contact with him? Yay or nay?
A work was performed. Let me see real quick.
Take your time. No rush. I don't see. All right, so
Does not appear she wants contact with the defendant, Your Honor.
no.
No
All right,
contact.
so, and I'm entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Robles as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Yes, sir.
If you violate this court order, the state can and will file additional cases against you, a violation of a protective order, and it's one of the worst misdemeanor cases you can pick up. So just stay away. Don't have contact with her. If she texts you, don't reply. If she calls you from an unknown number, hang up the phone. Just don't have any contact and everything will be fine. How old are you, sir?
22.
What do you do for a living?
I'm a technician right now.
And what kind of money do you make a month?
Sorry?
How much money do you make a month?
$3,500 a month.
And who do you live with?
With my mom.
We're going to reset your case to give you time to hire a lawyer. So I'm going to have you come up here. We'll have you sign for the order for protection. I'll have you sign a reset with Victoria. We're going to get you out of here to hire a lawyer. After that, I'll have you take a seat while we get your bond conditions. We'll have you sign it. And after that, you'll be free to go. Okay? Come on. If you can file no contact and no weapons.
Yes, sir.
3,